approach?
Wait a second, let them clear out so we can hear them. All right, we're ready to hear you now, sorry.
Yes, good morning, Your Honors, and thank you so much.
If you would, Ms. Henry, yeah, either pull it over or that we want to be sure we can hear.
Okay, is that good?
Yes.
Can you hear me? Okay. Thank you again, Your Honors, for giving me an opportunity to present my case. I appreciate it. And for your leniency throughout this process. It's been difficult for me, but I think we've gotten to here today, and I'm very happy about that.
Let us make sure that you understand the procedure here. You may already know it from having watched, but each side has 15 minutes total. Since you're the appellate, you can reserve some portion of your 15 minutes, up to 5 minutes, to do rebuttal after your opposing counsel over here goes. So
Okay.
you can use all 15 minutes now, and then they'll get their 15 minutes, and that'll be it. Or you could use some portion of your time and reserve time to speak after they finish. It's your choice.
Okay, I don't have any way of knowing the time, but I don't anticipate that my argument's going to take the whole 15 minutes. I think probably less, and then hopefully I can rebuttal. We'll see if I have time for that.
Why don't we kind of have to do it beforehand. How about we reserve 3 minutes? So you'll have 12 now and 3 minutes to do rebuttal if you want to.
Yes, sir, that sounds
okay?
fair. Thank you for that suggestion.
Go ahead, please.
Let me know when you're ready for me.
You have a very soft voice, so be sure you stay in front of the microphone so that we can hear.
Absolutely.
Thank
Are
you.
you ready for me to begin?
Yes, you can begin.
Okay. All right. We're here today because of the appellee's calculated and persistent misrepresentations. This began in 2019, first with me and the seller and the court, and then to a state regulatory agency. And it continued in 24 because Mr. Hanson continues to state in his pleadings that I purport that there were settlement agreements, when we now know that he was aware of the details, then they were unfulfilled because he made changes to them. And I found that email, he made changes to the addendum, and I found that email following that hearing in July of 24. At what point, I can't say that I was shocked, but it was another layer of complexity to this case. They've historically relied on procedural dismissals, and that began with a premature trial in 2019 where there had been no discovery, and that resulted in a default judgment where they apparently concealed and misrepresented facts in my absence during a medical emergency with my son. The second time was in 2020 for res judicata, where I attempted to re-argue facts that had not been substantially argued to begin with because of the default judgment. But the court used their discretion at that time to not allow it, and they dismissed for res judicata, and stating in the order that the facts could have been litigated at an earlier time. My point and my argument at that time was Rule 60. I cited fraud, mistake, excusable neglect, and I think all of those things applied given the duress of the situation and the disability. However, I came back, I went on to, like I said, file with the state regulatory agency to get more information. And I was not well at that time. We've stated that many times throughout these pleadings. And third is when I came back in 24 with this new evidence. And despite of these continued separate incidences of misrepresentations, and including the ones made to the Real Estate Commission, the court decided, and also a documented incapacity, the court decided that it was moot and stated that on the order. Okay. And I gave notice of the disability in my pleadings on July 29th, 2024. In fact, I detailed when I described the equitable tolling of statutes for incapacity, and that there was a forensic doctor I referred to in the witness list, and stated his potential impact on the previous judgments, and even the relevance in 220 because of my not being well at that time. I didn't state that on the witness list, but that was part of the impact that expert witness was supposed to have to describe throughout the litigation when I was able to prosecute and when I wasn't. At all times, to the best of my ability, I tried to come forward and describe and explain to the court that I felt these judgments should be void because they weren't based on the true facts. Mr. Hansen noted that himself in pleadings during this appeals process, that they've been hard to follow. And if you look at Volume 2 of the record, I had noted that, I think, in my response. There were repeatedly, I filed the same complaint 3 times when I filed the case in 2020. And at that time, I also asked for urgent motions to continue and did my best to describe the situation. Just as soon as I was restored in 24, presumed to be, I again came forward with a motion to vacate. And again, the appellees said the matter was res judicata. And the court agreed that it was and that the matter was moot, although this case has never been adjudicated on its merits, and that's typically a requirement for res judicata. So that's why I believe that it's fair that the situation that I describe is accurate, and that they probably made the same misrepresentations and showed the same false evidence to the court that they did to the Real Estate Commission. I believe that's a fair assumption. And it was not considered by the lower court, so that matter's not been adjudicated at all. And for these reasons, I think that res judicial requirements have not been met, and that all of the dismissals have been procedural. And I respectfully request that you remand this case so that the layers of this deception can be investigated. And I think that I have substantially proved that they concealed the payment of $1,500 for the summons. And I think that I have also provided evidence that they've manufactured false documents and presented them to the Real Estate Commission. Being for electrical payers, they withheld funds from the seller. I can't guarantee these things were shown to the court, but they were shown to the Real Estate Commission. They've not been litigated. And at that time, I had an opportunity to regain my home and to recover my losses for my investment, and they misrepresented. And code violations, they conspired to create code violations that didn't exist. It was, they actually presented a picture and wrote in my address on the wrong picture for another property they managed up the street. My property was always maintained very well. And the reason that they were asked to set a meeting with the owners and to negotiate things before, while they were harassing me and doing the things they did, was so that we could resolve those issues. So all along, they've just continued to do the same thing and not be honest in every situation I've tried to approach. So That's why we're here today. And I hope that you'll remand this case for further investigation to the lower court. Thank you for your time.
Thank you. You have your 3 minutes for rebuttal if you want to use it after counsel over here goes.
Okay.
Okay. It'll be up to you. We're here from Appalachia.
May it please the court, Andrew Hansen here on behalf of the Appalese. As I believe you're already hearing, this is a case that is now several years in the making, and it began with the filing of a General Sessions Court case in Washington County for unlawful detainer for breach of lease. That was by property listing, one of the Appalese against Ms. Henry. Ms. Henry responded to that with a countersuit of her own, claiming that she didn't breach the lease. We did.
Counsel, pull the microphone up just a little bit.
Just a little bit.
Thank you.
All right. So at the end of the day, that progressed to the point where there was, in fact, a trial in General Sessions Court. Of course, there was no discovery because it was a General Sessions Court case. And in that case, the defaults were granted, and a default judgment was entered against Ms. Henry in both matters. She did appeal the General Sessions Court case that was the unlawful detainer case, but she didn't perfect that appeal, and that appeal was dismissed in the circuit court. She never appealed the countersuit, which again was decided against her by default. So flash forward nearly a year later, instead of having completed any appeals on those cases, she files a new circuit court case. And in that circuit court case, she makes a number of allegations, including fraud and misrepresentation, and seeks to vacate the General Sessions Court decisions. The appellee here, property listing, filed a motion to dismiss on the grounds of res judicata. All the arguments that Ms. Henry was making pertain to, was there a breach of the lease or was there not? Well, that is the crucial element of both the General Sessions Court cases. The circuit court granted that motion to dismiss, and I should note that originally in the circuit court case, the judge was Judge Gene Stanley, who retired. And so when this case comes back around later on for the motion to vacate, we do have a new judge, and both judges reached the same decision on this point. And that is that res judicata did in fact bar the new lawsuit that was filed by Ms. Henry. Ms. Henry did not appeal that decision once again. Instead, more than 3 years later, she has filed a motion, essentially, I'm going to call it a motion to vacate. It had a very long name. I'll call it a motion to vacate or set aside. And essentially made the same arguments that she made in her original circuit court case, and she's again seeking to vacate the decision not only of the circuit court, but also the prior decisions of the General Sessions Court. A hearing was held on that motion to vacate, and at that hearing, the circuit judge, the new circuit judge on the case, Judge Cook, once again denied the motion. An order was entered to that effect, and it is that order that is on appeal here today, not the original decision from the circuit court itself, but just the order denying a 3-year later motion to vacate. As a threshold matter here, I understand that Ms. Henry is pro se, and that's fine. However, it does not alleviate the requirement that she comply with the rules of this court. And in particular, as we've argued in our brief, she failed to do that with her brief, and it's part and parcel with an overall problem in this case. Not only does the brief lack a table of contents and authorities, but its statement of facts doesn't even cite to the record. And there's a reason for that, and the reason is because the record is a jumbled mess of various notes and handwritten pleadings, typed pleadings, you name it, that Ms. Henry has filed in the case. Honestly, it's difficult to follow for anyone what she even claims the fraud is. But ultimately, what it's clear that she's saying is there was some fraud in the sense that she says there was no breach of lease, and the appellees say there was. That's the fundamental issue. Now, if in fact there was disagreement about that, which there was, that's what the original litigation was for, and it was decided in those cases. Crucially, Ms. Henry's motion to vacate was wildly untimely. It was brought under 60.02, and as this court is aware, if the basis for that motion is fraud or misrepresentation or other misconduct of an adverse party, that motion must have been brought within 1 year of the judgment. In this case, we're talking about more than 3 years after the judgment. And on top of that, in this case, Ms. Henry's also seeking to vacate the original General Sessions Court judgments. And in that regard, TCA 16-15-727 actually limits it to a 10-day period to file the motion to vacate for fraud or misrepresentation. Either way, we're well beyond what the rule allows. In an effort to get around that, Ms. Henry's tried to argue that she is somehow entitled to put the pause button down on that rule by virtue of what she claims is a disability. Of course, nothing in the record actually supports such a disability or offers any proof of such a disability, but it really doesn't matter because there's nothing in the rule and nothing in any applicable statute or citation that Ms. Henry has made that suggests that the 1-year period runs in any event. Ms. Henry seems to rely on 28-1-106 regarding tolling of the statute of limitations, but that statute does not apply here. That statute applies to commencement of a new action, and that's not what this is. This is a motion to vacate an old action. And even then, if it did apply, it really is triggered whether the disability exists when the cause of action accrued. And here, Ms. Henry is claiming that she became disabled on March 21, 2021, and that she learned of the quote-unquote fraud on March 5th of 2021. Presumably, she claims that she's getting that from information that was included in a response that was filed with the Tennessee Real Estate Commission. And it is true that Ms. Henry did file an ethics complaint, which was dismissed. And it's true that a lot of information was presented in response to that, and that's because no one was trying to conceal anything or defraud anyone. And I can assure the court that I certainly didn't do that. There was some discussion about a settlement agreement, and Ms. Henry, as her own pleadings indicates that there were discussions of a settlement agreement. There were attempts to negotiate a settlement agreement, but it wasn't signed. And in response to that, there's nothing in the record about the settlement agreement in any event, so the court should disregard the discussion. But just so the court knows, that was the circumstance. It just wasn't signed. So if that were an issue to be raised, it should have been raised in the General Sessions Court case. But in reality, the settlement fell apart and did not get consummated. And so, in short, the circuit court here was correct to deny the motion because it was wildly untimely. Another basis that the court had for that was the res judicata argument that exists from the original circuit court decision dismissing this case. It continues to hold true today. All of the elements of res judicata are met here. There was an underlying judgment rendered by a court of competent jurisdiction. The same parties or their privies were involved in both suits. The same claim or cause of action was asserted in both suits, and that includes, under the transaction standard that the court has adopted, claims that arise out of the same transaction or series of connected transactions, and claims which were or could have been litigated in the former suit. It's exactly what we have here. All of these claims relate to the lease and or the breach of lease, and that's it. That's really what all of the claims here are. So as argued more fully in the brief, all those factors apply, and res judicata does apply here. Ms. Henry argued in her rebuttal brief, essentially, that based on Turner versus Turner, res judicata doesn't apply because she claims that the underlying judgments are void. That is a misreading of Turner versus Turner. Turner versus Turner dealt with a case where there could have been a void judgment for lack of jurisdiction. We are not dealing with a case where there's a lack of jurisdiction, personal or subject matter. We are dealing with a case where the allegation is fraud or misrepresentation. And so even by virtue of what Turner has to say, it's not a void judgment. If it could be, if she were correct and had timely brought a motion, none of which is true, but if she had done that, it would have been a voidable judgment, which is not the same thing. And since she brought her motion far too late, she cannot argue that point any longer. And by the way, it should also be noted that in Turner, the court did express the position that with respect to a 60.02 motion like the one we have here today, the standard of review is abuse of discretion. So really what we have here is a case where there's no question that the time limit to bring this motion is expired. And there's no citation to any authority to suggest that it could be told. And that is why here we are today, several years later, still wrestling with this same case after multiple efforts to do so. We have asked for attorney's fees here for a frivolous appeal because we believe that it is frivolous. In the previous circuit court case, Judge Stanley actually admonished Ms. Henry that if she continued on and filed a new matter, she could be subject to an award of attorney's fees. Evidently, that made no impression on Ms. Henry. So instead, she's pursued this case aggressively, and she continues to make numerous filings, wasteful motions, and she makes personal attacks against both the appellees and counsel. She's filed an ethics complaint with the Tennessee Real Estate Commission, which was dismissed. And all of this has shown a disrespect not only for the process, but for the court itself. The appeal is frivolous. It's been mean-spirited. It's been wildly misguided from the very start. And appellees are requesting attorney's fees in this case. Thank you.
Thank you. Ms. Henry, you have some time if you want to speak now. I think you got three minutes for rebuttal if you want to.
Yes, sir, I appreciate it. Okay. Would like to state that the Real Estate Commission complaint was not dismissed. It was not followed up on because of
Pull the microphone down some.
Yes, sir.
Thank you.
the Real Estate Commission did not dismiss my complaint. I was not able to follow up on it because that is within a couple of weeks of that time is when I had what they believe, it was symptoms of, it was blackout. I don't know how to describe it, but it was symptoms of, at that point they basically incapacitated me because I couldn't understand really basic things. That's a pretty low bar, and it was very hard for me to believe it was true. But it prevented me from taking any further legal action, not necessarily with that regulatory board, but my health did at that time. I just couldn't go forward, and I think that it's reasonable to believe that's the case, or I wouldn't be standing here these years later and upset about it to this degree. And I'm not a hateful person, and nothing I've ever did here was with intent. I paid everything they asked me to pay and met their unjust demands because I knew I wasn't well and I could not navigate that process. So that was the best attempt I could make, was just to pay. The lease was never breached. What happened, and it's been real clear in pleadings, is they stated that the payment was due on the 1st, and we had two different documents. That's where the discrepancy came in. One stating payment was due on the 17th, the other on the 26th. And although the one that stated it on the 26th needed to be, that was the one that we were going to transfer the terms of onto an addendum and state that they would just maintenance the systems until closing. My original investment had never been actually accounted for, and neither had the investment that I put into the property. And the other thing is that it was just at all times impossible for me to navigate this process. Those false statements on the summons is the original problem. There was no breach of any lease. And the other thing I want to mention, he hit on the judges. We had two Sessions Court judges. The Honorable Judge Nonifert passed away, and he knew I'd paid the summons. And then Judge Arnold took over the case, and he's now deceased as well. So I couldn't go back to the same judges. That's why I went on to the circuit court with my new case, with my new claims in 2020. And that's why that this forensic doctor was so relevant, because he could have told why I couldn't proceed in 2020 and 2021 and described it in great detail. And that's why that it was very important that the court consider that documented disability, which had never been brought forth before, and that incapacity. It hadn't happened until 2021, so I couldn't have brought it up in 2020 or 2019. And Judge Cook did abuse her discretion by not hearing it, in my opinion. That's real hard for a pro se plaintiff to say, but that's what I believe in my heart. And I believe in my heart that at all times they worked with bad intent while I was honestly trying to do the right thing from a disadvantaged position. And again, thank you for your time today.
Okay. Ms. Henry, and you may already know this, you can sit down. We're limited to what was in the record before the circuit court. You know, that's what the law says we have to do. We have to look at what the record was before the circuit court, as far as facts and all that, of course, in the law. We will take the case under advisement. We'll arrive at a decision, and we'll send you and your opponent over here our opinion at the same time, so you'll both be notified at the same time. Okay? Thank you both for your arguments this morning and your briefs. If you would, recess court till 1:30 this afternoon.
All right.